The Property Protection Trust does have one limitation, however, and that is that because it's part of a will trust, it only comes into operation when you've passed away. Therefore, at best, in the case of something like long-term care, it can only protect half of the house. Now, if you want to protect all of the house, this is where the Lifetime Family Asset Protection Trust comes in. Now, lifetime trusts and trusts in general are something of an enigma. People don't like talking about them, and often there is, ironically, a distrust of trusts because they're not in common parlance. But in fact, trusts have been around for approximately 3,000 years. The first known mention of trusts being by Homer in his Iliad. Now, modern trusts were developed around the days of the Crusades, with the Romans having brought the concept of the will trusts to these shores when they invaded. So for anyone who thinks that trusts are a modern idea, look back in history and realise that they have been around in their current form without many changes for a long, long time. Now, put simply, a lifetime trust is a trust that you set up when you're alive. You don't wait until the will kicks in after death for that protection to be put in place. Now, take an example of a couple. Imagine a husband and a wife. Imagine they put property protection trusts in their wills, but imagine they both end up in care. How much protection is there for them? The answer is none at all, because they're both alive. Their PPTs in their will have not yet kicked in. Now, if this is of concern, what should they do? They should take that idea of setting up a trust and putting their respective shares of the property into trust and do it now. Do it during their lifetime. Now, if both of them end up requiring care, the property is already in trust. We don't have to wait until they've passed away for that protection to be effective. Now, one of the things that concerns people about putting their properties into trust is this notion of deliberate deprivation. Are we allowed to put our houses in trust and other assets to avoid long-term care fees? And the answer is we are. The legislation, the Care Act of 2014, is very, very clear. We can do what we like to protect our assets, to minimise the tax that falls due when we pass away, providing that it is done at a time when the need for care is not reasonably foreseeable. That means acting soon whilst you are mentally and physically as fit as possible. Now, the penalty for deliberate deprivation is not something to be afraid of. I had a client once who was concerned that they were going to be dragged into the local market square, put in the stocks and pelted with rancid vegetables. And that's simply not the case. Deliberate deprivation just means that the property will be taken and sold to pay for those care fees, which, if you think about it, is exactly what would happen if you'd done nothing at all. Nothing ventured, nothing gained, nothing lost. All that you've lost, if you want to look at it like that, is the cost of having established the trust in the first place, which in most cases is just the equivalent of a week or two's worth of care fees. Because care fees varies across the country. Clients who live in London and maybe in Surrey could be facing care fees of over £100,000 per person per year. Whereas in rural Gloucestershire, for example, it could be as low as £40,000 to £50,000 per year. But that's still a lot of money to be paying, and most people do not have that disposable income to pay for those care fees. When that income runs out, the local authority traditionally would have forced the property to be sold by getting a court order, and they would have used the money to subsequently pay for those care fees. But the local authorities are a little bit more clued up now than they used to be. And what they will do now is offer what they call a deferred payment arrangement. And that is a charge over your property which must be repaid when you pass away. Now, the problem with a deferred payment arrangement is there's interest. And nowadays, interest will run not from the date of death until the date the debt is repaid, but it will run from the date that you required care. Now, usually the interest rate is something between 7 and 10%. meaning that your family, when you've passed away, will have to get the property sold in order to refund the local authority. Now there lies a big problem. You can't sell a property until you've got a grant of probate. You can't get a grant of probate until inheritance tax is paid. And you can't pay the inheritance tax sometimes until you've sold the property. You've got a perpetual loop. Now, if the property is in a family asset protection trust, the trust can be structured in such a way so that the property can be sold without the need to obtain a grant of probate, meaning that those funds are flexible, hopefully not to have to pay too many debts that you leave behind, but that they can be there to provide those legacies for the grandchildren, for your family, without what is at the moment maybe a 6 to 9 month wait for a grant of probate. So the Family Asset Protection Trust is not something to fear. It's not something for the super rich. It's not something that's complicated. If you're trustees of your own trusts, you don't lose control over your home. You're not giving up the decision-making process about when you move and where you move to somebody else. What it is an effective asset protection trust tool, which will leave you in no worse a position than if you'd done nothing at all. Everything to gain and nothing to lose. Something I'm often asked is when this loophole is going to be closed. Now, what we have to remember is that those who pass the legislation, those who sit in the House of Lords, as was the Supreme Court now, always have in the back of their minds the thought that they don't want to be undoing any planning that they've done themselves. Tax statutes, trust statutes, if they are changed, are not retrospective in their action. So anyone who has got a trust in place can pretty much guarantee that the law, if it does change in the future, will not affect the planning that they have put in place. We have to remember that the Family Asset Protection Trust is not an inheritance tax planning tool. Inheritance tax planning with the family home is notoriously difficult due to complicated rules about being able to live in your property rent-free, so that's not what we're trying to do. But the trust is structured in such a way as to make use of all the current inheritance tax exemptions and allowances. For example, the residential nil rate band and the transferable residential nil rate band. But if inheritance tax planning with trusts is something that you're interested in, then we do have the Settler Excluded Asset Protection Trust. This is a trust not for the family home, but for other assets, which if you put them into trust more than 7 years before you pass away, the value of those assets will be outside of your estate for inheritance tax purposes. And this can all be done without triggering charges to capital gains tax, thanks to various exemptions and reliefs. And if this is something you are interested in, please do ask and we'd be more than happy to talk to you about it. So we have what I term the triangle of estate planning. We have wills, we have lasting powers of attorney, and we have lifetime family asset protection trusts. Wills appoint the persons that you choose to look after both your children and your assets to ensure that they pass to your chosen beneficiaries as quickly and as smoothly as possible when you pass away. We have lasting powers of attorney, which are documents that appoint the people that you choose to make decisions about your property and financial affairs and your health and your welfare when you're no longer mentally able to do so. And then we have lifetime family asset protection trusts, which protect your assets against third-party attack from divorce, from bankruptcy, from foreign taxes, and potentially from future care fees. Now, I wish I was able to cover the whole of the United Kingdom, but unfortunately, I'm not. So I work with a network of trusted associates, strategic partners, who will be able to provide you with bespoke advice about some, all, or other aspects of estate planning that we haven't necessarily covered today. So give them a ring. Find out what they can do to help you. Now, you may choose to put all of these things in place or none of them, but at least have the conversation to understand the consequences of the decisions that you're making. You can go in fully informed to make sure that your family's future is as protected as it can be.